A common question we get in domestic violence cases when somebody's charged with a domestic violence crime is, can my spouse, my ex, my child, my parent, my brother, whoever was the victim of the domestic violence charge, can they drop the case against me? They don't want to prosecute me. They understand that this whole situation was blown totally out of proportion. The police came, I got arrested, but now that things have settled down, they want to drop the charges against me. Can they do that? The answer is really no. They don't have any unilateral authority to do that. They don't have any charging decisions. They don't have any dismissal power. There's no way that they can just go in and voluntarily drop the charges. That's not how our system works. So let's break it down. Let me explain how it does work so you have a better understanding if you've been charged or your loved one has been charged and you want to drop the charges against them. Here's how it works. So let's say that A and B are two people, they're in a romantic relationship, and they get into an argument together. Somebody calls the police on somebody else, police show up, B gets arrested. So the police are here, and they decide to investigate the case, they arrest B. So B is now being charged with some sort of disorderly conduct or assault or trespass or something, and they're tacking on a domestic violence designation. So B is arrested by the police. The police then turn the charges over to the prosecutor. This is the prosecutor symbol. It's the prosecutors of the city, of the county, of the superior courts, wherever this case is going to be filed. Charges are turned over to the prosecutor. Prosecutor reviews the case. Charges are then prosecuted in the court. So we're going to call this the judge. This is the court. So now all of this is happening. It's going up into this pipeline here. Well, now let's say A wants to drop the charges. So A doesn't want to be involved in this. A was contributed just as much to the whole altercation as B did. And so A wants to say, all right, I'm going to go into court and I'm going to tell the judge that I want these charges dropped. Well, unfortunately, it's not going to do any good. The judge has no legal authority at this stage to take a look at the charges and just dismiss the case. So people like A, they'll come to our office and they'll say, hey, I want to waive my rights to be considered a victim. I want to talk to you guys, your defense lawyers. I want to help my husband or brother or whatever through the situation. How can I help? I was planning on just going and talking to the judge. Like I said, it's not going to do any good. The judge doesn't have the authority to just take the case and just dismiss it. They have to hear the case on the merits. The case is now being prosecuted by the government, by the prosecutor's office. And so if A is not involved, the prosecutor doesn't really have to have any leniency on them. The prosecutor can just say, hey, we believe there's enough evidence based on the police report to move forward with the case. We believe there were enough admissions. We believe there's some other evidence that we can use. And so just the fact that you don't want to you don't want to be involved, you want to drop the charges, it's outside of A's control now. It's all in the prosecutor's discretion. So the prosecutor can decide whether to move forward or not. And the reason they do this is because the prosecutor wants to kind of discourage this from happening. The prosecutor doesn't want these situations to unfold, and then 2 weeks later, A to come back, get the charges dismissed, and then the whole thing happens again. Now it's back in the prosecutor's desk, and they have to deal with it a second time. So by and large, most prosecutors throughout the state of Arizona, they're going to prosecute these cases regardless of whether A wants to be involved or not. So just because A wants to drop the charges doesn't mean that the charges are going to get dropped. It's now up to the prosecutor's discretion to decide what they want to do with it. Now, if the case does go to trial, or if there are a lot of plea negotiations, say B hires an attorney, the attorney comes into play, that's us, we're the defense attorneys, we can communicate with the prosecutor and say, you have very weak evidence. A doesn't want to be involved in this. A is going to testify on our behalf and that they contributed to the altercation. There was self-defense arguments. There was mutual shouting back and forth in a disorderly conduct case. Everybody was drunk. Nobody remembers anything. And there's a lot of stuff that happens. And in some situations, A is just not around anymore. A moved states. The relationship fizzled. A doesn't want to be in Arizona, doesn't want to be involved in the prosecution at all. And so the prosecutor, their key witness, who is this person, they're the victim of the crime after all, if they're not going to come into court and testify against B, and the prosecutor goes into court with no evidence, remember, most situations, the police show up after the fact. They show up after the allegations, the alleged crime has already been committed. And so without A in court testifying against B, a lot of the times the prosecutors have very little evidence that they can actually introduce. So the prosecutor's not going to look at that and say, well, we're going to voluntarily dismiss the case just because A doesn't want to be involved in it. They'll take it all the way up to a trial, the day of trial. If they don't have a witness there and they don't have any other evidence that they can go on, they may have no choice but to drop the charges or dismiss the case. But it's not going to happen just because A asks nicely. There's a policy reason for that. They don't want to encourage that type of thing to happen. So the long and short of it is, can your ex drop the charges against you? No, there's no legal authority for this person, A, to do that. They have no legal power. Once the charges have been filed, it's outside of their control. But there are legal possibilities that we can use to preclude the prosecutor from being able legally, or based on the rules of evidence and criminal procedure, from actually introducing any evidence against B, and they'll have no choice but to drop the charges. It's a lot more nuanced than that. There's a lot that goes into it. It requires a very thorough review of police reports and conducting interviews and those things, because there are certain exceptions and there are possibilities where the prosecutor can perfectly move forward against B without A. A can be in China and they can still move forward with the case. So it's important that you give us a call. If you've been charged with any type of domestic violence situation, whether you're the victim, whether you're the person being charged, if you're the victim and you want to move forward with the case, you obviously do not want to call us, okay, because we're going to be representing the other individual. But if you are somebody who understands that this whole thing was a misunderstanding, you want to help, there are certain forms and certain ethical requirements that we have to go through, because you have a lot of rights as a victim. But we'll make sure that we explain those very thoroughly. Either A or B, if you're watching this video and you're on either side of that coin, give us a call. We'll be able to sit down with you, review the facts of your case, make sure we have a good plan to navigate this. You can see it's a little bit complicated, but it's something that we do very regularly. We have a great team here. We offer free case evaluations. So give us a call. We'll get you scheduled. We'll sit down. We'll make sure you have a good plan moving forward. Thanks for watching.